Great job, Jake. Thank you very much. Our speaker this morning is Lisa Sommer Devlin. We're honored and privileged to have her with us today. Her legal practice has concentrated in hospitality law for 25 years. She drafts standardized contracts, provides legal training, and handles meeting-related litigation for chain and independent hotels. Meeting News magazine named her one of the 25 most influential people in the meetings industry in both 2002 and 2006, and actually said that more than anyone else, Ms. Devlin is the legal voice for the industry. She speaks at countless industry events and was named a 2012 Best in Class Speaker by PCMA. So join me now in welcoming your speaker, Lisa Sommer Devlin.
Got it. Okay, good morning, everybody. Hardest part of this is getting up those stairs without falling and knowing where the clicker is. I've got those two things covered. I've been doing this for 30 years, and I tell everybody I started when I was 6, right, like all of you did. So what are we going to do today? Well, what we're going to do today is we're going to talk about the hottest topics in the legal industry, or the legal side of the meeting industry. Lots of times I give presentations, we do deep dives on liquidated damages or cancellation or attrition or those kinds of things. And you all have probably heard that. So I thought I'd talk about the things that have really been bubbling up for the last year or so and that are really the big topics that I'm hearing new things about. So that's what we're going to talk about. Before I do that, of course, I have to do a legal disclaimer. I have to tell you that the things I tell you today are not legal advice. They are educational, and that if you have specific legal questions, you should contact your attorney directly because this is not to be a substitute for legal advice. Having said that, I'm hoping we'll have enough time at the end of my presentation that I'll be able to answer a few questions because there's always something I talk about too fast or I go over too quickly or whatever it might be. So jot down your questions and I'll have time afterwards as well if you want to ask something specifically. And of course, my opinions are those of myself and have nothing to do with this lovely event that you're attending. So let's talk about this. Why are we here? Well, 2007 brought up a bunch of stuff that continues in 2018. We had hurricanes in Puerto Rico and in the South. We just had a hurricane a week ago. I had 2 sons living in North Carolina and they were like, oh, Mom, it'll be fine, but I was freaked out. We had wildfires here in California that impacted a lot of properties. A client that I work with literally had to evacuate in the middle of the night on about 20 minutes notice and burn to the ground. So, lots of things happened. We had politics. If we've learned nothing else in the last couple of years, we know that anything can happen when it comes to politics, and that's trickling down into our event industry. We had the Me Too movement. Again, I had the TV on this morning. It continues to be a thing. We've had gun violence, Las Vegas, and many other places. And so I see in the meeting industry on the web, I see on the chat rooms, I see in articles, I see meeting planners talking about, well, gee, do we need to address these issues in our events? Do we need to address them in our contracts? Is there something that we should be thinking about that we haven't thought about before? And are there practical things or are there contract clauses that you should be doing? So how many of y'all that are sitting here are meeting planners? Okay, how many suppliers? Okay, so pretty evenly. Sometimes, you don't get that in these kinds of audiences. So these are things that are bubbling up, and I'm getting clauses from my hotel clients saying, my meeting planning friends want to do this, what do you think about that? And my reaction, which may surprise you since I'm a lawyer, is that additional contract clauses are not always the answer, especially for the kinds of things that we're really talking about. And why do I say that? Well, it's for a number of reasons. First of all, when you insert a new clause into a contract, until it goes in front of a judge or an arbitrator and you get a legal ruling, you don't really know whether or not it's a valid provision. You don't really know how it's going to be interpreted or how it's going to apply. So inserting a new clause isn't necessarily going to solve your problem. And nobody really wants to have to go all the way through litigation to find out if the clause that they're using is appropriate. I have meeting planners tell me all the time, I've used this clause for 25 years, and I always say, well, that's great. Have you ever had to apply it? Have you ever had to go in front of a judge and defend your clause? Well, no. And I'm like, well, then you don't know whether or not your clause is valid or not. Another issue with adding new clauses is that both sides have limited legal budgets. When you try to draft a new clause to address one of these situations, you're probably hesitant to call your lawyer and get help on that. which may cause problems down the road. And the hotel people often are less experienced than you. I'm sure you've all experienced this, that seasoned meeting planners like yourself tend to be working with hotel salespeople that have only been in the business for a few years. And they don't know a lot about how to evaluate clauses. They don't know how to think critically about those things. They don't have necessarily a lawyer they can go to get help. And so when you put in something new or unexpected to address these issues, it slows down your contracting process and may cause more problems than you're solving. What you really need to do with these issues is balance the risk of whatever this is happening, the hurricane, the flood, whatever it might be. You have to balance what's the odds that that's going to happen versus do I really need to approach this legally, or can I deal with it when it comes up? And something we're going to talk about in more detail later on that a lot of meeting planners don't think about is if you add clauses addressing specific things, and you're assuming responsibility for that, you could be exposing yourself to additional liability. And that's a legal concept that a lot of meeting planners don't know about and that it's important to understand. And finally, just because it's in the contract doesn't mean it will be followed. When you put in a new special kind of clause in the contract and then that contract gets turned over to the convention services people and then it gets turned over to the banquet captain or whoever it is, most of the time they don't even read that contract. They're going about their job the same way they always do, and they don't even know that it's there. So you may not be solving the problem that you're trying to solve because nobody's paying attention to it. So what do you do? What are your concerns? Excuse me. The first thing is always force majeure. Everybody's talking about force majeure, but they don't really understand it. The basics of force majeure are very simple. First of all, you don't need a clause at all. If something unexpected happens that impacts performance of your contract, the law will step in and excuse you if it's appropriate. You don't need a clause at all. Under the clause, it is a very limited concept, and it truly means that you cannot perform the contract due to unanticipated circumstances. Now, what I see in the meeting industry all the time is that customers want to expand these clauses, and they want to add additional language beyond what is typically contemplated in these contracts. And what you're essentially asking is you're saying, we want to be able to walk away from this contract without paying for more reasons than we ordinarily would be able to. And that's why you get pushback from your hotel partners, because the hotel partner is saying, I don't have to let you out of the contract for that reason, and I don't want to. I want you to have to be obligated to pay. And so you have to understand when you're negotiating these clauses what it is that you're asking the other side to do and evaluate accordingly. The other thing is that is often discussed in force majeure is if this terrible thing happens, fire, flood, whatever it is, what level does it have to rise to in order for the parties to be excused? And the typical under the law is illegal, impossible, or commercially impracticable. Not impractical, impracticable. Impracticable is a legally defined term that I always say it's like what the Supreme Court says about pornography. It's difficult to define, but I know it when I see it. Impracticable means you could technically still perform the contract, but because of some unanticipated thing, there's no purpose in doing so. And the best example I can give you is that if you have an event where Joe Blow is coming to speak to your attendees and Joe Blow ends up in the hospital with a gallbladder attack, you could still have that event, but there's no purpose because Joe can't be there. That's commercially impracticable. Technically you could perform, but there's no purpose. And so those are the typical standards that are out there. What I see meeting planners and others want to add is less high standards, like inadvisable, material impact, impractical, and they think, well, that's going to get me out of this contract if it's not strictly impossible, but something goes wrong. The problem with that is that you're just buying a dispute. I see so many times where a customer decides, for whatever reason, they don't want to have this event, and they come to the hotel and they say, see, it's impractical because of whatever this is. We don't have to pay and we're canceling. And you got to be sure that the hotel is going to say, no, it's not, and we're going to expect you to pay, and then you just bought a lawsuit. So, I've had a million of these over my career. Best example is post-Hurricane Katrina in New Orleans. 2 years later, I was getting people saying, well, we can't come to New Orleans because the city's not the same. That's not a force majeure. That's not, but then they would turn to these things like impractical and say, we get out without payment. And I can assure you that my clients did not just say, okay, go ahead, you don't have to pay. So adding those terms you might think helps you, but it really doesn't. It just creates disputes and problems. Another thing I see people add in force majeure is undefined terms or overly broad terms, like threat of terrorism. I'm sorry, folks, it's 2019. We've been under a threat of terrorism since probably the early 1990s, the first time they tried to bring down the World Trade Center. So what's a threat of terrorism? At what point does it make your meeting impossible or impracticable to have? I love another one, severe inclement weather. What? What does that mean? I don't know. But if you say one thing, this is bad weather, we're not coming, and the hotel says the other, again, you've just bought yourself a dispute. On the flip side, last week when it was Hurricane Florence, I didn't have my phone ringing off the hook over letting groups out because, like I say, when you know it when you see it. We had an event that was scheduled in Dallas, but it was for a company that every single person attending was from North Carolina. So yes, they could technically still have the event, but the customer came and said, look, all of our people are in the process of moving their kids and their dogs and evacuating and boarding up their windows. They can't come. And we said, you know what, you're right. You are excused from this contract. On the flip side, we had another event that was supposed to go to New Orleans, and it was from people all over the country, hundreds of people from all over the country. Were there a few from North Carolina? Sure. But the event could still go forward. There are just a few less people, a performance issue, probably well within their allowable 20%. So that event, we said, no, you're not excused. Yes, there's a hurricane, but it doesn't prevent you from performing. So force majeure should be a practical analysis. It shouldn't be a get-out-of-jail-free clause, and unfortunately, too often it is viewed as a get-out-of-jail-free clause. I'm pushing the wrong button. That makes a difference. So remember, you can agree on broader terms if you want, but you need to make those terms unambiguous and objective so that everybody knows what they are. So I always try to rein things in, declared war in the United States, not just war. We've been at war since 2001. Terrorism in the city where the event is happening, or something very specific so that everybody knows when that has or has not occurred. So how do you deal with hurricanes and fires and these kinds of things? Deal with it as a partnership, as I described. The clause is not necessarily the answer. The important thing is communication with your business partner and communication with local authorities. Do both. So if you're planning to go somewhere where there's fire, then you should be contacting the local emergency authorities and asking them what their predictions are. You should be contacting the hotel and saying, what's your plan? At what point are you going to shut down or evacuate? Work together to evaluate the risk and talk about both sides of it. Like, okay, I get it. You may not know until 2 days out whether or not this hurricane's going to turn or not, but my people have to know. My people have to make a decision. Talk about objective things. I had friends who were supposed to go to a wedding last week. They couldn't go because, I'm from Phoenix, if you were flying out of Phoenix, you had to go through Charlotte. Well, guess what? The airlines canceled all the flights out of Charlotte. So that was obvious, people couldn't get there. So you should be talking with your business partner and say, let's talk about the practical realities, let's talk about what you think is going to happen, and let's agree together on a go, no go. And if that occurs, then we can walk away and not pay. Keep in mind that there's financial impact on both sides. Not only is the hotel losing your revenue, but you're going to lose money as well in having to reschedule or move your event. Consider working with the hotel company, and I've seen this happen many times, especially after Katrina. The brands said, let's look at every contract we have in the next 6 months for New Orleans, and let's sit down and find every other hotel out there that can take them and help them move. Those are the kinds of partnerships that you should be having, rather than just saying, I'm walking away and I'm not paying you. If your event is a revenue-generating event for your organization, it's very important that you have event cancellation insurance, so that if something like this happens and you were going to make $1 million on your event, you're going to get paid for that. It can be pricey to get, but it's usually pretty good coverage, and it's worth getting so that you're protecting yourself if something goes wrong. And always remember, Whether or not your contract says including but not limited to, even if you have a very tightly worded force majeure clause, if something truly happens, if the aliens descend and you cannot have this meeting, a judge is going to let you out. And I swear to God, I've had somebody put in zombie apocalypse in their clause. I am not making that up. And I'm like, all right, we'll put that in, whatever. What are the odds of that? So, there's always an excuse. If something truly happens that you could not anticipate that makes performance impossible, you're going to be excused. So avoid these 2-page long force majeure clauses. They're not helping you. They're just buying disputes for you. Which leads us to politics. Let's be clear. Politics are not a force majeure. Okay? Politics do not prevent anybody from having a meeting. It may mean you don't want to, but if you don't want to, that's a cancellation. If you can't, that's a force majeure. So if you want to cancel due to political reasons, you owe cancellation damages unless there's a specific clause in the contract allowing you out. Now, as I mentioned, I'm from Arizona. Arizona kind of led the way on some of this with our SB 1070 about 10 years ago. And it's a very good example of why these political clauses are so dangerous. Because they passed a law that half the country said was the most discriminatory law in the world, and the other half of the country said, no, 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 it's not. And then immediately it was challenged in court, so the most egregious portions of it never went into effect in the first place. And there's still litigation trailing about the whole thing all these years later. And so how does that impact groups' responsibilities when they say our people don't want to come because we think you're a bunch of bigots? Well, unless you have a clause, you can certainly decide you want to leave because you don't like that state's politics, but you're going to have to pay. And you've got to understand that the hotel is not going to want to accept that kind of clause. It is a business issue, not a legal issue. And really what you're saying is to the hotel, if your state does something we don't like, we want to walk away and have you bear the burden of that loss. To which the hotel is going to say, well, but we don't like the law either. In Arizona, we kind of woke up afterwards and there was another law that was proposed, and all the hotel community got together and went to the legislature and lobbied and said, don't do this, and it wasn't passed. So many times, the hotel partner that you're working with was just as against the law as you are, so why should they bear that financial loss? If you know that your attendees have political feelings that are going to impact whether or not they want to go to your event, that is something that you should get on the table immediately when you start the negotiations so that the hotel knows that this is an issue. And you should start negotiating that clause and how it's going to apply. One thing I have recommended to some groups with strong political opinions, they say, well, yeah, we don't want to pay the hotel because it's not our fault either that our attendees won't come. Maybe you come up with somewhere in between. Maybe they pay half the damages for cancellation that they would have paid if they canceled for just a business reason. Come up with some alternative, rather than just saying, if we don't like your politics, we can walk away. Now, there are a number of model, I will say, clauses that have been floated out there in the industry. I will tell you, and I will tell them to the organizations that drafted them to their face, they are terrible. They are terrible because they have undefined terms. They cover things that are not prohibited by law. They don't say who gets to decide. And again, as in my Arizona example, who decides whether the law is discriminatory? One of the clauses says if the new law has the effect of. Well, who gets to decide that? You're not getting yourself out of a contract. You're buying a dispute because the hotel is going to say the law doesn't say that. That isn't what it means, so you can't cancel because of that. Or you're buying yourself a dispute because the hotel says we don't agree that it does that. Or the hotel's going to say the law didn't go into effect because there's a lawsuit. So I don't recommend those clauses. If you are part of an organization that has strong political beliefs, you really need to work with your lawyer to draft a clause and work in partnership with the city and the hotels that you're working with. It's very, very hard to draft. I will tell you that I have not seen one that I thought was not subject to problems because politics are very messy. So, it's out there, I understand, but be cautious when trying to do that because you're not getting a get out of jail free clause, you're just getting yourself litigation, and I don't think anybody wants that. Sexual harassment, again, recent discussions and ongoing discussions are a good thing. but I've seen a lot of, especially associations and political type groups, coming to hotels and wanting to add clauses about what the sexual harassment policy should be. I don't think that you need to do that for a number of reasons. First of all major hotels have sexual harassment policies. So if you go on their website and go to their legal portion of their website, you will see that they already have in place a policy about what they prohibit and what they can't do. And if people really are going to engage in that kind of behavior, having a policy isn't really going to change what they're going to do, as we all know. Also, I've seen things where they want specific protections for the employees. Again, the law already protects all the employees. You don't need to have a clause to be protected from sexual harassment. It doesn't get you anything more than you've already got. And the biggest thing that I worry about in this is, as we're all talking about now, is the mere fact of an allegation does not mean it's true. And so when you hear that a hotel has had a lawsuit filed against it because of discrimination of whatever kind you can make up or sexual harassment, that doesn't mean it's true. I can go out today and file suit against every single one of you if I want to spend $50 and go to the courthouse and file. It doesn't mean what I claim is true. And the sad reality, I don't know if it's sad, but the reality of life in America is that 99.9% of all lawsuits that are filed are settled out of court without a determination of fault or liability or whatever it is. And so the mere fact that there has been a suit filed or the mere fact that there has been a settlement does not mean that anything necessarily happened. And so again, if you have people, by the way, line employees, if you put something specific in the contract, the line employees are never going to know it. If you put something in the contract, it's not going to protect you. You have to be able to work with your business partners to say, how are we going to respond to this? What are we going to tell our attendees about what is going on? And usually it's the better approach is to say the hotel denies the allegations, here's what they're doing training, they're doing this, they're doing the other thing, to convince your people to come anyway, rather than walking away due to a mere allegation. You have to publicize that. You have to let your attendees know what you're doing. Your hotel partners are going to be very willing to work with you on doing those kinds of things. They will be very willing to help sponsor a, sexual harassment class for your event, or they'll do whatever it is to show that they are trying to act in good faith so as not to impact your meeting. That's a better solution than having a sexual harassment policy. Now, internally for your own organization, if you don't have a policy, you need to get one. If you don't do some kind of training within your organization about what's appropriate and what's not appropriate, you need to do that. You need to be talking to your labor lawyers about those issues. Not that it's going to protect you from liability, not that it's going to keep people who are bad from doing bad things, because that's the way life is. But if you have those policies in place, it is a partial defense. You can hold up if somebody makes a claim and say, this is not who we are, this is not what we do, et cetera, et cetera. There's also a growing trend in the meeting industry to talk more openly about the types of things that can happen at events, because as one of my colleagues says, gee, you're in a hotel, you got beds and booze, it's a petri dish for inappropriate behavior, and it is. So, it's a good thing for your organizations to talk with your membership about, this is what is okay, this is what is not okay, and get that out there and get that on the table. Which kind of leads, sort of, I guess, to emergency preparedness. Always a good idea for your organization to get emergency contact information from all of your attendees as part of the registration process. We all know that anything can happen in today's world, and things can change on a dime. That example I gave you, the hotel that had to evacuate within 30 minutes due to a fire, you kind of needed to know who to contact people if something went wrong in that scenario. It's always good to review emergency information at the start of your meeting. The responsibility is ultimately the venue's, but it's good for you as a meeting planner to review that with your people. Here's where we're going to meet if we have to evacuate. Here's where the defibrillators are. Here's where the exits are, those kinds of things, so that people are not taken by surprise when that happens. I'm seeing a lot more organizations that either have an app for their meeting or they provide a number for people to check in, so that if something goes wrong, if they get stranded somewhere, whatever, they know who to contact to get help. And that's very helpful to show, again, that you're trying to do things appropriately. Something that I see a lot of and that customers get frustrated with is they ask for a clause that says, in the event any of our attendees get injured or has a problem, you will notify us. Well, your hotel partner is not going to do that. They're not going to agree to that clause. And it's not because they're being different. It's difficult. It's because the hotel has its own obligations to those guests. So if Susie attendee drinks too much and takes some guy from the bar back to her room and he robs her and she reports it, Susie may not want you to know that she did that. If Bob does something stupid and trips and falls and breaks his leg and goes to the hospital, he may not want you to know that he did something stupid. So it's not that the hotel is unwilling to share that information with you. They have to protect the privacy of their guests. And so if you want to know that kind of thing, generally what I'll put in the clause is we will notify you if the injured party or the complaining party or whatever you want to call them agrees to that. I mean, it's not that they don't want to tell you, it's that they've got to protect the privacy of that individual. And it's not necessarily a good idea to take on more obligations. And this is what I talked about earlier about assuming a duty. In general, the hotel or the venue under the law is responsible for the security of the premises. So they're responsible for making sure that you don't trip and fall over the rugs or the cords. They're responsible for making sure that there's emergency exits, all those kinds of things, and for the security. The group is only responsible if you cause the injury. Otherwise, you're not responsible. So if you didn't put down the carpet, then you're not going to be responsible. The only potential liability you might have as the group is that you might be responsible for negligently picking the venue. If you go to a place and you see it's a fire trap and you see that the floors are uneven and all those kinds of things, and you book it anyway, you might be responsible for that, but it's unlikely. But otherwise, you're not responsible for what happens. But if you take on a responsibility for safety that is not yours and you do a bad job of it, then you can be held responsible because you've negligently assumed that duty. So what does that mean? Let's say you put a clause in the venue contract mandating specific kinds of safety procedures. You will have one defibrillator in this room, and the hotel complies with that, and the person who drops dead, well, let me give you a better example because that's not a good one. You will have somebody on site at all times who is trained in CPR. And the hotel says, okay, we have somebody trained in CPR, and the person drops over, and the person trained in CPR is at the other side of the property, and it takes them 10 minutes to get there, and you're relying on that person, and by the time they get there, the person's dead. Their family might say, you told them they only needed one guy, and that wasn't enough, so you're responsible. Another example that may be more obvious is you're doing off-site busing to an event for your attendees. And your attendees get there and they say, we've decided that we want to walk back. Is there a safe route for us to walk back and get to the hotel? And then they walk back and they get mugged or whatever bad thing happens to them, and they come back to you and they say, you told me that that was the safe way to go. I relied on you and you assumed that responsibility and I got hurt, so by the way, you owe me a bunch of money. So your response when your attendee says, what way should I take back, is let me show you to get back on the bus. That's what you say. You don't give them an alternative that may or may not be a good idea. Of course, it's important to ask your venues, whether it's this or a hotel or whatever, if they have a safety and security plan in place. If they don't, you shouldn't be booking them. Most of them will. But do not expect them to just hand it to you. They spend a lot of money working with security consultants to come up with their security plan. Part of the essence of that security plan is that people don't know what it is, that they don't know where the secret cameras are, that they don't know, this, that, or the other thing. So they will share certain things with you, but they're not going to give you the whole security plan because that undermines the entire plan. Always develop a plan for your organization for safety. Your people that are running your event should be trained on what your security plan is, where people are supposed to go, whose responsibility is whose, and you should train on that so that if something goes wrong, if something terrible happens, then you can say, look, we've trained, we prepared, we did everything we could, and it's not our fault that people got hurt anyway. If your event has particular risks, work with the venue and their security team and your insurance company. You know, you may not be aware of this, but your liability insurance company, they don't want to pay claims. So they have people that they will send out to help you work with your event to identify potential risks and to identify ways you can do things in a safer fashion. You're paying them a lot of money for that insurance, ask them to help you, and they will be happy to do that. If you have particular things, you should be having meetings with your venue in advance. If you've got a high-profile person, then you need to have a particular security plan to get that high-profile person in or out. If you have high-dollar items being on display, that's a different security risk, and you need to get all that worked out and confirmed in writing. That's an amendment to the contract that as you're getting closer to the event, you're doing an amendment that says, here's what the security plan between us is going to be, who's responsible for what, et cetera. I went to a hotel one time and they had NFL Super Bowl rings just sitting on a pedestal in the middle of the lobby. I was like, holy moly, you know, those things are worth a lot of money. And I went to the front desk and I said, shouldn't there be somebody standing there? They had not had a discussion between the organization that was displaying them and the hotel as to whose responsibility it was to guard those rings, and so nobody was doing it. So that's not the kind of thing you want to have happen at your event. Do not disturb policies. Again, there's been a lot of discussion about that in light of the Las Vegas shooting. Some hotels have changed their policies. Some hotels have said we will no longer honor it. Some have changed policies, and I've seen a lot of customers want to put clauses in the contract saying, here's what the hotel's do not disturb policy is, you will not change it, and we're going to publicize this to all of our attendees. Not a good idea. The innkeeper has a stringent legal duty to protect their guests. It comes back all the way down from the common law of England, and the innkeeper was responsible for anything that happened, regardless of whether or not it was the innkeeper's fault. And they still have a very stringent duty. Varies by state law, but it's a very, very high and stringent duty. They have to be able to change those policies depending on what the circumstances are, whether it's on a day-to-day basis or a going forward basis or whatever it is. So they are not going to agree in their event contract with you as to what their policy is or going to be 2 years from now when your event's finally going to happen, because they have to be flexible on that. And as an event planner, I say this in the nicest way possible, it's not your responsibility. Okay, if your attendees don't want the housekeeper coming in because they don't want the housekeeper looking at their underwear, or they don't want them smelling, they don't want to smell the cleaning supplies, or whatever it is that they don't like, that's between the attendee and the hotel. And if an attendee comes to you and says, I'm gluten-free and I don't want them bringing muffins in my room, or whatever it is, your response to that should be, you need to go to the hotel and talk to the hotel directly and make arrangements for whatever it is that you're willing to do or not do, and what they're willing to do or not do. Do not assume the responsibility of promising your attendees what the do not disturb policy is or is not, because it may change, and then you're going to be in trouble. And I just saw, and I can't remember what the event was, but there was a major citywide in Las Vegas, and there were people printing all over LinkedIn, oh, I'm in this hotel, and they're coming into my room whether or not I want them to, and they're ignoring my do not disturb, and isn't this terrible? And they have the right to do that. And so don't tell them that they're not. Because on the flip side, there could be sex trafficking, there could be drugs. 10 years ago, it was really cool for people to rent hotel rooms and cook meth in the hotel rooms. It's kind of gone out of fashion, thank God, but you know, if the hotel thinks that's going on, they've got to be able to go in and check on that. And so do not assume that you're helping by saying something about the do not disturb policy. Do not assume that you should put a clause in that says all of the housekeepers will have panic buttons. I've seen that recently. You know, there are a million permutations as to whether or not a hotel is going to give housekeepers panic buttons. And believe me, they are not going to change their policies because one customer asked them to do that in their contract. So even if you put that in there, it's not going to happen unless they decide that it's going to happen for other business reasons. So don't go down that road. All right, I went fast, so we've got plenty of time left, so I'm happy to entertain your questions. What burning issues do you have that you're dealing with in your contracts? Yes, ma'am. The question is, her force majeure clause says act of God, does that include a hurricane? Yes, an act of God is a hurricane, so yes. But the question is, you say it's in South Carolina, the question is, how is that venue directly being impacted? I gave the example of my sons living in North Carolina. They're in Raleigh-Durham. They had a little rain, that was it. So, you can't just assume, in our 24-hour news cycle, we see all this devastation, and it's terrible, but it may not be where your event is. And so there needs to be that communication saying, what happened? How is this impacting you? Is there any change that we need to make? But yes, an act of God would be considered a hurricane. Okay. Next question?
Hi, I'm also a hospitality attorney. I think you did a terrific job.
Oh, thank you.
I'm very impressed.
He's not a ringer. I've never seen this man in my life.
No, it's true. I just wanted to add one thing, because there's certain hidden clauses that hotels like to get in. I call them hidden clauses, but they're in plain sight. Every contract I've looked at practically says that the organization will be responsible for any damages or any problems caused by their attendees. I have been able to, on every single occasion, get that clause stricken. If an employee does something, yes, that's different. That's what we call respondeat superior. But on the other hand, if it's an attendee not connected to the administration of the organization, I change the clause to only if the person causing that damage
And I agree with you,
employee.
and that's one of those circumstances where I say if you don't ask, you don't get. So they ask for it, and sometimes they get it, and sometimes they don't, and that makes sense. But let me tell you about the flip side in that. I see it especially in what I call sports contracts, where volleyball tournament comes to the hotel, and they bring 60 14-year-old boys that are coming for a volleyball tournament, and they're dropping things off the atrium into the lobby of the hotel and breaking them. And then, of course, when the hotel says, well, all this stuff is happening, who's going to pay? Of course, nobody ever admits, and they can't prove, and those kinds of things. So sometimes when we have organizations or groups that we think are more likely than not to cause some kind of damage, we like to add that responsibility for the attendees' actions, because we say, you're in the better position. As the event sponsor, you can then turn around to your attendee and you say, I know Bobby, and I know it was Bobby that did it, and I can make Bobby pay me as part of his registration. He agrees that he's going to, be responsible for his own actions, and then it trickles down, because the hotel doesn't know those individual guests or who's doing what the way that the event sponsor does. But I get what you're saying, and that's part of the negotiation process. So, another question?
Hi, Lisa.
Hi.
My name is Tisha, and I'm having a problem with one of my groups right now. I work at a convention center. In our contract, we require our clients to provide their own general liability insurance. We have a clause in our contract that says their policy must cover independent contractors. And one of my groups wants us to take that out because their policy doesn't cover independent contractors. And my attorney from the convention center is saying, no, we can't take that out. And so we're kind of at an impasse now because this is a youth group, a faith-based group, and they can't buy more insurance, and we can't strike that clause from our contract. So is there anything that we can do to just mitigate that situation?
Well, there's a couple things there. And again, this is the same kind of trickle-down concept as we were talking about. When you have an organization coming in and they're renting the convention center, and then they're having exhibitors, and then the exhibitors are bringing in their independent contractors, the trickle-down is the convention center doesn't even know who those contractors are, and they want to be protected in the event those contractors do something and cause injury. And so that's why they have those clauses, and the problem is people don't enforce them. They put it in their contract, but then they never demand the certificate of insurance, so it's meaningless because they never get it. Insurance is available. Whenever an organization says we can't have insurance or we don't afford insurance or whatever it is, I always say, if you're a non-for-profit, you're the most obvious person to have an insurance policy, because if you're Hilton Hotels or this place, you've got a lot of money, and if there's something that goes wrong, you can afford to pay if you have to reimburse somebody. But when you're a small organization or a nonprofit and you don't have a lot of assets, That's exactly when you need to buy insurance, because that will protect you in the event a claim is made. And so when somebody says we can't, the better answer to that is no, you don't want to, and you should want to. And the easy way to deal with that is you can go online and Google event insurance. They can get a policy that just covers them for that event for that day at a pretty reasonable cost, and then it will protect them and it will satisfy the organization. So it doesn't have to be an impasse, you just have to figure out how to get around it. Got a question over here.
Good morning.
Good morning.
So my question is, as a meeting planner, I go back and forth as we get closer and closer to the convention or to the conference, and the person I signed the agreement with, we're making changes, but we're running out of time as far as doing addendums to the contract. Are they still legally binding if they commit to a certain thing or allow us to do certain things via email?
Probably not. And let me tell you a couple of things about that. There's a lot of confusion in this industry about amendments and addenda and what they are and those kinds of things. The first thing is when you're negotiating a contract at the beginning, it is not a good idea to have the venue contract and your addenda stuck on the back. You should negotiate one complete agreement and put together all the clauses that you can accept, rather than having essentially two contracts that you've stuck together. That's not what an addenda is. An addenda is something that you add to a contract to clarify the agreements. Best example I can give is you've got a contract to buy 50 bicycles. The addenda would say 25 are red, 25 are blue. You're not changing the material terms of the contract, you're just clarifying them. That's what an addenda is. It's not something you sign at the time the contract is signed. Now, what you do when you're making changes after the fact is you are amending the contract. And every time you amend the contract, you need to go through the entire contract and say, how is this changing things? If I'm adding guest rooms, how does that impact my attrition? How does that impact my cancellation? How does it impact anything else? And you need to go through and document all of those changes. As you're getting closer and closer to the event, I know things get tight, and sometimes you don't have time to do those things, but an email under the current law, unless you have specifically agreed in your contract otherwise, an email would not be a proper amendment, because most amendments have to be in writing and signed by both parties. So you can send an amendment by email back and forth, but you have to have that piece of paper that people have signed. Now, some contracts say that the parties agree that additional things that are ordered on site will be considered valid, so that exactly that kind of thing you're talking about. Last minute you're saying, we need to add 100 cookies to this event. If they serve those cookies, they're going to get paid for them. But it's always a good idea to sit down every day with your hotel representative and say, okay, here's the last minute things we did, let's agree. And then you can sign off on them right then. An amendment does not have to be formal typewritten. It could be in handwritten and you both sign so that you both agree on it. That's one good way to do it. Yes, ma'am.
Good morning. My name is Alice, and I have a question. I'm a planner, and I'm not sure if I noticed that. I was looking up and writing, but if, let's say here at the convention center, as a planner, because a lot of times I ask now, because if I'm especially faith-based and I have, accessibility that's needed, and things like that. I guess what I'm trying to get to is that, can you ask a venue or a hotel to give all of your exits, all of the emergency, I guess, for risk in case something happened?
Sure.
For weather or what have you? Because
Sure.
I did ask one hotel and they just looked at me like I was crazy.
No,
and never gave me that visit.
No, and I think that should be part of your pre-planning discussion, is you should say, I need a list of all the exits so that I can tell my people. Because you, as the meeting planner, when these people come in, you should be saying, here's where the exits are, here's where the defibrillators are, or whatever it is that you think is appropriate. So no, they're not going to give you their whole security plan, but certainly they should tell you where their exits are, because that's what your people need to know. And then you also need to know who is the person at that venue who's responsible for those kinds of security issues, and you should be asking your attendees during registration, if you have particular accessibility needs, please let us know and we will introduce you to Joe Security, who can help you with that. So that, again, you should be making those connections so that they're working with the individual in the hotel or the center, rather than you being responsible for that, because you don't want to take on the responsibility for getting them in or out. Are there questions? Yes, sir. Got one over here.
Our organization has a lot of offsite events, And it was great that you brought up that if they decide to take their own route back from those events that we've provided transportation to, then we need to be careful of our advice. But what if we have events and we just tell them that transportation's on their own to and from? Are we opening ourselves up as an organization?
No, because
for
in
any
that
problems?
in that instance, you are not giving them advice as to how to do it. So you're saying you're on your own. Get there whatever way you want to, and get back whatever way you want to, and you figure it out. We're not telling you the way to do it. So you're not assuming that responsibility. So that would be okay. It's when you say, walk down this road, or take, this particular driving company, this particular service that turns out not to be insured, that's when you're going to be in trouble.
Okay.
I want to go back to your force majeure clause. I have an organization, it's 5 planners who's planning a conference, a major conference. These are 5 equal partners who are putting on an event and pretty high celebrity profiles. One of the 5 no longer has major surgery, no longer able to attend and be a part of that. Can that force majeure clause in terms of the commercial and practicability apply?
Let me make sure I understand. You're saying that you're having an event where you're going to have 5 major high-profile people that this event is about, and
Yeah.
one of them's not there? That's one of those, I'm not sure. It would depend on all the circumstances and how much that person was going to do with this or that or the other thing. The better way to approach that kind of situation is, if there is something specific about your event that you need to have in place, that should be a separate clause in the contract. So you should have a clause that says, it's a contingency clause saying, this event is contingent upon these 5 people being there. And if for any reason any one of them can't be there, then we can walk away without payment or whatever it is you agree on. Those kinds of contingency clauses are used a lot in pharmaceutical events. We are having this event for the purpose of launching this particular product.
Right.
And if the FDA doesn't approve it, we can walk away without payment. We are having the event for, whatever it might be. Then you have a separate clause. It's not really a force majeure, it's a contingency that everybody knows that this event is dependent upon that thing happening or not happening. And that's the better way to handle that kind of situation.
Thank you very much.
Sure, particularly true when you've got an individual that is key to your event. Because otherwise, the hotel is going to say to you, I didn't know it was about these 5 people. We're still open, we're still available, you can still have your event. So you want to make the participation of that individual, or whatever that fact is, a condition of the contract, so then they can't say, well, we didn't know. All right, well, we got like a minute left, so it's perfect timing. Thank you. Again, I'll be around if you have a question you want to ask afterwards.